Judge, this is case number 26CR 0024 LHB, State of Georgia versus Jessica Maria Motes. Before the court on defense motion to dismiss the indictment, special demurrer, as well as an amendment to said motion.
All right, and we have counsel for the defendant present, and the defendant is also present and in the courtroom. And I am ready to hear evidence and or argument in regards to the demurrer. I've had an opportunity to review to the motion that was filed on August 5th, and I'll hear from counsel.
Good morning.
Good morning.
And since Your Honor has stated that the court has read both motions, I will not go through everything that's mentioned in those motions. There is specific cases that I do want to mention and highlight some of the language in those cases.
Thank you.
Okay. I think the first thing we want to talk about is that the defendant is entitled to an indictment that is perfect in form, and that the offenses in that indictment have to be stated with sufficient certainty. And this is the Kimbrough case, which I think is actually in the motion, and that's KIMBROUGH versus the state at 300 Georgia 878, the 2017 case. And it specifically states where a defendant challenges the sufficiency of an indictment by filing of a special demurrer before going to trial, she is entitled to an indictment perfect in form. And it also goes on to state that the code section 17-5-54A also requires that the indictment state the offense with sufficient certainty. Inconsistent with the statutory directives, we've held that an indictment not only must state the essential elements of the offense charged, but it also must allege the underlying facts with enough detail to sufficiently apprise the defendant of what he must be prepared to meet in order for the defendant to prepare his or her defense intelligently. Now, in the part about preparing the defense intelligently would be at, I believe, page 881 or either page 882 of that opinion. And, Your Honor, that because I think is important in every single indictment. It becomes more important, of course, in murder cases. It becomes extremely important in a death penalty case where the state is seeking to execute this defendant if she is, in fact, found guilty. So coming into court, not knowing what you're defended against other than it's stating blunt force trauma and exposure to 3 drugs that is listed, there is a plethora of ways and means and circumstances that either of these events could occur. And in researching this, and I always thought blunt force trauma meant, you think blunt force, you think, oh, that's something that is so bad it causes a major injury. But blunt force trauma, when you look at medically what it is, it can be a bruise. It could be, or I think the other word to use for bruise is contusion. It can be a scrape. It can be any number of things that I think when we get into the legal field and we start looking at indictments of blunt force trauma, we always anticipate looking at something like a baseball bat or a hammer or something like that, something we automatically know that's going to cause significant harm. But blunt force does not mean significant harm. Blunt force can basically be anything other than what I would characterize as something like with a sharp instrument like a knife or scissors or something that pierces the body, as opposed to being blunt force trauma. And I'd like to go on, Your Honor, and my apologies to the court and counsel, but I really do not know how to pronounce this case. Is a state versus CERAJEWSKI. And it's at 347 Georgia App 454 2018 case. And what it states is that 17754 is satisfied if it states the offense in terms or language of the code or so plainly that the nature of the offense charged may easily be understood by the jury. But it also requires that an indictment state the offense with sufficient certainty. So consistent with these statutory directives, we have held that an indictment not only must state the essential elements of the offense charged, but it must also allege the underlying facts with enough detail to sufficiently apprise the defendant of what he must be prepared to meet. And of course, they're citing the Kilbrough case from that. But it goes on to say, and it's citing from the Delaby case here, which is Delaby, and it stated that the defendant is entitled to know the particular facts constituting the alleged offense to enable him to prepare for trial. And I think the important thing in this case too, and of course it is coming back and stating from the Kilbrough case in here, when it says, it is useful to remember that a purpose of the indictment is to allow a defendant to prepare his defense intelligently. So there has to be, when you look at an indictment, you've got, counsel has to be able to know enough to be able to say, okay, this is what I need to prepare for or defend against. And as stated earlier, when you've got the blunt force trauma, there's so many ways that blunt force trauma can occur. How can you possibly ever prepare a defense to prepare for what the state may adduce at trial? And it's the same thing, I think, with the exposure to the drugs. Exposure to drugs can occur in so many different ways. How do you prepare? Do you prepare that this defendant allows someone else to administer drugs to this child? Did the defendant allow someone else to smoke dope in front of, maybe I shouldn't say dope, but these alleged drugs in the indictment, use these alleged drugs in the indictment. Did this defendant leave these drugs laying about the house to where the child could accidentally ingest the drugs? Did she herself inject the child with the drugs? There's so many ways with that that you can't be prepared to defend every single way with the word exposure. And I think, and I know we've kind of been talking about the death, but these arguments also apply to the cruelty, because the cruelty and the felony murder also has the exposure to, it tracks the language, the exposure and the blunt force trauma. But also as to count 5, the concealing the death of another. What's interesting about that is it talks about, I think, concealing and hindering, or concealing thereby hindering, but there's no factual details within count 5 either. There's no description or clarification as to what she did or what she did not do in order to be charged under the concealing the death of another, for the defense to adequately prepare an intelligent defense for Ms. Motes. Now, within the amended motion, we talked about the fact that the state did not allege unlawfully. So I want to talk about a few cases about the unlawfully. And I know Your Honor is familiar with one of the cases that I'm going to talk about. But Montgomery versus the state, which is at 323 Georgia 119, and it is a 2025 case, it says malice is the unlawful intention to kill without justification, excuse, or mitigation. And then it goes on to say, because this was the case to where the jury found the not guilty on the malice and guilty on the felony murder, and they were appealing on repugnant verdicts. And what they talked about is that we have held that there is an important difference between the malice required for malice murder, the malice required for aggravated battery. The former is the unlawful intention to kill without justification, excuse, or mitigation, and the latter is an actual intent to cause the particular harm produced, that is bodily harm, without justification or excuse. And I think that language is important because what we have in the case before the court is the cruelty to a child in the first degree, which also has the element of malice in it within the definition of the crime, the elements of the crime, just as the aggravated battery does. And Montgomery, I think, definitely talks about that there is a difference between the malice in each one. So I do believe that the word unlawfully becomes extremely important within the count one with the malice murder. And then we have McGuire versus the state. And it states that, is cited at 307 Georgia 500, and the spelling of McGuire is M-C-G-U-I-R-E. And it states that a person commits the offense of murder when he, again, unlawfully and with malice aforethought, either expressed or implied, causes the death of another human being. And then, of course, it defines expressed malice as that deliberate intention unlawfully to take the life of another human being, which is manifested by external circumstances capable of proof. And then, of course, I think the court has probably charged enough jurors as to know that it talks about implied malice, and implied malice does not use the word unlawfully. And so what I wonder with this, and I've never seen it, but I or heard it argued, have not found it in cases, but that does it become an issue when the court goes to charge a jury? You know, that you do not have the word unlawfully within the indictment, but then the court charges, you know, where it's unlawfully. Is the court...
But doesn't the charge itself says at the very end, the indictment says in each count, at the very end of the charge, contrary to the law, statutes, and let me read specifically, contrary to the laws of this said state, the good order, peace, and dignity thereof. So in regards to the contrary to the laws language, isn't there a case from, it was like 1902 or 1920, it's an old one that says that when the word unlawfully is not included, that the indictment was saved based upon the contrary to the laws of said state added to the end.
And I think, Your Honor, this case is different because of what we talked about earlier with the malice being an essential element of the murder, an essential element of the cruelty to a child, that those are two different forms of intent on that malice. So that's why I think that the unlawful becomes more important, because contrary to the laws, the good order and peace thereof, I think it's kind of how it reads, is actually on every single count.
It is.
So there's not going to be, I think, any type of distinctions. But I just do wonder, though, you know, at a charge conference, I think it would certainly be something I think that would be objected to, because what I stated is that, well, you're given a definition that is not of a crime that is not contained within the indictment. Even considering what the court has talked about with the case, that thinking or stating that does the catch-all at the end of each count save the indictment. I think our position is that it would not. And I think one of the things too, when we talk about unlawfully and we talk about between express and an implied malice, I'm not certain how, when a death penalty case, how that's going to affect also when you're talking about a guilt innocence phase and a mitigation phase, or punishment phase, I should say, mitigation and aggravation phase, as if you've left out like an element, like unlawfully, that, you know, can it affect perhaps how a jury perceives someone when they're looking at express malice or implied malice, and the unlawfulness of whether or not that is actually in the indictment. Then we'll go to, I want to talk about, I'll probably kind of talk about them kind of together, Overstreet versus the State, 312 Georgia, 565, a 2021 case, and Snow versus the State. And it's actually, I do not have the Georgia side on that. I have 930 Southeast 2nd, 490, 226, and it actually has the number S26A0176. is what the number is actually now. But in Overstreet versus Estate, it talks about, again, that a person commits the offense of murder when unlawfully and with malice aforethought, either express or implied, causes the death of another human being, and that the state, of course, must prove malice beyond a reasonable doubt, as malice incorporates the intent to kill, and express malice being that deliberate intention to unlawfully take the life of another human being, which is manifested by external circumstances capable of proof, while malice is implied where no considerable provocation appears and where all the circumstances of the killing show an abandoned and malignant heart. So that's where I'm not certain how, because you've got unlawful mentioned within the statute itself with the definition of murder, but then you also got it within the jury charges of how expressed malice and implied malice is.
But it's not in the indictment.
Ma'am?
But the word unlawfully was not included in the indictment.
Okay, yes, ma'am. The Snow case, now, we recognize in Snow that of course, being honest with the court, as counsel should be, is that the court in that case said they would not allow or would not consider the demurrer post-trial because it had not been filed
Correct.
pre-trial, and they wouldn't even consider it. Now, and they said that it was dubious and what they thought, it might be a dubious argument anyway. And we are acknowledging that. But I think one of the things in the Snow case, which is 930 Southeast 2nd, 490, a 2026 case, and I think I'd already stated that, but that dealt with a malice murder and aggravated assault family violence. The aggravated assault family violence does not include the element of malice within the definition of the crime, unlike our indictment, which talks about the malice with the malice murder, and then it has the cruelty to children, which talks about malice again. And again, we state that those are two different forms of malice. So I think that is one difference, or it's a huge difference to distinguish it from what we're talking about today. And also think, the fact that this is a death penalty case, that we all have to have higher safeguards to make certain everything is correct. Mm-hmm. That, I think making certain that an indictment is correct in form is one of those first areas that we need to have, that is perfect in form and that is sufficiently tells the client what she has to defend against. One of the things, the last two cases I do want to mention to the court would be Villa Corta-Padilla versus Estate. That is VILLA-CORTA-PADILLA, and that's at 378 Georgia App 653. It's a 2026 case. And Blackman versus Estate 272 Georgia App 854. That's a 2005 case. And what they deal in here, these are cases that talks about dates in an indictment and the need for specificity. And particularly in the Villa Court case, it talks about a charging instrument subject to special demurrer if it's not perfect in form, as well as the substance within the indictment. And within this case, this is another Hall County case, and of course in this case they were concerned with dates, about shortening dates, could they shorten the dates or not. Within this case, the state actually called a forensic interviewer and to see whether they could or could not shorten the dates within that. And the court says, in meeting its burden of showing that it's unable either to identify a specific date on which an offense occurred or to narrow the range of possible dates, the state is required to present some evidence and may not rely solely upon argument by counsel or mere speculation. Now, what's interesting is that it goes on to state that in carrying its burden of showing that an indictment cannot specifically identify an offense date and must instead rely on a range of dates, the state would typically call a lead investigator or some other law enforcement witness at a special demurrer. But nevertheless, there's no formal requirement that the state adduce such evidence or testimony to shoulder its burden in this connection. Neither is there any requirement that the witness who testifies at the special demurrer hearing must also have testified before the grand jury. Now, that almost seems to be saying, the opposite. It's like, well, the state doesn't have to, but then it does say the state has to present some evidence. And I think, Your Honor, with that we can, if the state has to do it in order to try to narrow the dates, present some type of evidence, they should certainly do it when you got an indictment such as this, when you cannot tell anything by what's alleged in there. And Blackman was just another one that talks about the specificity of the dates. And in that case, it said the court had recognized an exception to this rule where the evidence did not permit the state to identify a single date on which the offense occurred. However, this exception is not applicable in this case because the state never presented any evidence before the trial court showing that it cannot more specifically identify the dates of this offense. And I think that is why the Blackman case is important, that some burden should be placed upon the state to produce some type of evidence. Your Honor, within their indictment, there's no what, there's no where, there's no how in reference to the trauma. There's no specificity whatsoever. And the exposure to the drugs allegation, it has the same fault. How do you defend when you are not put on notice how or what happened? How the child was exposed? Was it by making her swallow drugs, ejecting her? A combination of ways, leaving the drugs so the child could accidentally get hold of them? Did the child inhale them while someone was smoking the drugs? Was the victim exposed to the drugs because of contaminated surfaces, clothing, or otherwise? Was she exposed by allowing her to be in the presence of others that had the drugs? And I think one other thing, too, is that there's certainly even no mention of the level of drugs within the indictment. Is the allegation that a little itty-bitty amount of drugs caused the death? Or, there should be something more specific that why the exposure to drugs caused the death. What is the lethal amount of the exposure that would lead to death? Because I think we all know that some exposure would not do it. It's got to be a certain amount of exposure. And we would need that in order to adequately defend against the charges. And the same malady also applies to concealing the death of another, that the count 5 of the indictment. You don't know what happened, what was, was something said, was something done, how it happened, where it happened, or anything within that. I think it's just a merely somewhat follow the code section, I believe, but there's nothing in there to adequately, defend upon that. So do you say, well, every conceivable way that this could have happened, is that what we're prepared to defend? That would be impossible to do. So, Your Honor, in conclusion, this our position, of course, that the indictment is woefully inadequate as to how all of this happened, and there's no way, particularly this being a death penalty case, that we can adequately defend this client with this indictment.
Thank you. And Mr. Buckler, in looking through the demurrer motions, it looks as if there's several specific phrases that are called into question, specifically blunt force trauma with no other language associated with it, the object unknown causing the blunt force trauma, the word exposing, and then the not having the word unlawfully contained within the malice murder charge. And so in regards to the specific objection to the object unknown causing the blunt force trauma, In my research, I think the Wyatt case, and that's 295 Georgia 257, allows the state to use the language unknown object. In that case, the Georgia Supreme Court found that with the indictment alleging aggravated assault with hands and an object, the description of which being unknown was sufficient because the state could not be more specific based upon the evidence that they had. So I'm less concerned about the phrase unknown object, because if the evidence does not allow the object to be identified, that's permitted. I am, however, concerned about the lack of the word unlawfully in the malice charge and the general description of simply blunt force trauma and the word exposure. All of the research that I conducted in regards to the blunt force trauma language, all of the appellate review using that language and the sufficiency of it generally had language associated with it, blunt force trauma causing severe head injury, causing a ruptured spleen, causing, for instance, the manner of the blunt force trauma, right? Was it struck? Was it hit? Was it kicked? Unknown to the grand jury because they were, or to the state, they didn't have necessarily the weapon that was used. But the blunt force trauma, all blunt force trauma does not cause murder, does not cause death. And so all of the research that I did had at least something that gave the defense an idea of what blunt force trauma is associated with the death. And so the language always had, again, blunt force trauma causing ruptured spleen, blunt force trauma causing brain bleed, and so walk through that specific argument because I think the state may have a problem.
And that's what defense put in her motion, or in the past, hit with a baseball bat did cause brain swelling, hematomas, did cause some type of internal injury that we can look at some internal organ and say that organ failed, and as a result of that, this child died. And Your Honor, that is not the evidence that I would anticipate is going to be introduced in this case. If the state believed that this child died of a brain hemorrhage, we would have alleged that. We believe that the child died of a of damage to the heart or mesentery or internal bleeding. We would allege that. However, that is not what I anticipate the evidence of trial is going to be. I anticipate, Your Honor, that when our medical examiner takes the stand, she's going to testify the child died as a result of, in her words, blunt force trauma and exposure to these drugs.
Your Honor, I think, object to anticipating what someone's going to testify to. I think the best evidence of that would be to have that medical examiner here to testify as to if she couldn't specify it better, why she couldn't, or perhaps, be subject to cross-examination and say, could she? But just having the state to either refer to a report or to refer to a conversation, we would state would not be the best evidence. We'd object to that.
Your Honor, the court is, Your Honor referenced the Wyatt case, and that's about the best case that I've found as much on point as possible. Quote for Wyatt, "The sufficiency of the facts before the grand jury to justify the charges in the indictment cannot be questioned, and the recitals concerning knowledge or want of knowledge of the names of the parties or other matters must be accepted as truth." And that's why there is no requirement to have an evidentiary hearing in a specific demur.
I'm going to overrule the objection requiring live testimony made by defense.
And if I could say this, the state is well aware this is a very unusual indictment. I don't think I've ever in my life put this many phrases like expose, unknown to the grand jury, the nature of which, I don't know that I've ever put that many into an indictment. And I guess I kind of struggled over this week trying to figure out, that just seems entirely, wholly, and totally unfair to Ms. Motes, especially given the fact we're trying to execute her as a result of what she's done. And I've been kind of struggling with, as defense counsel's correct, man, we have to go above and beyond in a case like this just because the sentence that we're seeking is, in fact, so severe. And it occurred to me, Judge, in a very realistic sense, it's the state of Georgia that is going to be limited by this just as much, if not more, than the defense. I've tried a number of murder cases in front of Your Honor. We tried the Rucker case where the gentleman shot somebody else at one of these hotels. And it occurred to me, well, why did we even allege that? If we don't have to, why allege that he used a .22 handgun to shoot that poor guy if it's not required? Well, the reason is, Judge, when we're putting up this evidence and it becomes very clear how this child died, okay? If there is evidence of brain swelling, if there is evidence of damage to the internal organs, if there is evidence the child was hit with a baseball bat stick, something like that, then the state of Georgia now has a very serious problem. We've now got a fatal variance between what was alleged and the evidence at trial. At trial, Judge, we have to prove beyond a reasonable doubt that this is unknown. There are going to be theories, there are going to be, we can go ahead and speculate, all right? But we can't, it's not that we can use this to make sure that there are 50 different ways to do it. If we think that there was an injury, a specific injury that killed that child, and we haven't alleged it, but that becomes proven at trial, Judge, we're cooked. The court is going to find that the evidence we have put up does not match the evidence that we have alleged. We are constrained by this indictment just as much as the defense is. And it's for those reasons that there has been a lengthy investigation into this case. This case was presented to the grand jury. And although I understand the amount of things that we have not alleged, that we would typically allege in a murder, we always, when we can, allege exactly what that person did when that's known to us, when that's known to the grand jury. One of the cases that I worked on back when I was in a different office was the Gary Hinton trial. Shannon Melendi, who ended up, we think, ended up in a wood chipper, this girl from Emory who disappeared. We never found her body. We never even found her body. And we charged with murder, despite the fact we were never even able to allege. The Supreme Court, in response to that, held that, quote, an indictment failing to specify the cause of death is sufficient when the circumstances of the case will not admit of greater certainty in stating the means of death. Judge, that was Hinton versus State, 280 Georgia, 811 from 2006. Your Honor, if the state is being disingenuous, and in fact, we know what happened, what this woman did specifically, if we know what act she committed, what injury specifically killed this child, if we know all that and we are holding it back until trial to gain an advantage, Your Honor will prevent us from doing that. The court, according to Wyatt, has to accept that the indictment is true, and if the indictment is true, that means, Your Honor, that the grand jury does not know any more than we've alleged. As they also said in Wyatt, the state cannot be more specific than the evidence permits. That's on page, well, that's on page, I believe, 505 of Wyatt. Yes, Judge, I agree. I absolutely wish this was well, I wish it had never happened, but absent that, I wish this was a shooting, a stabbing. I wish that the evidence would be clear as to the manner of death over and above blunt force trauma and exposure to these drugs. That is simply not what the evidence is. You know, if it was a shooting, then we would just argue about why there was a shooting. Or we would argue about who shot, all right? We wouldn't have to argue about all these things that as of right now, the state does not, although we can kick around theories, you know, like in Wyatt, Your Honor indicated specifically that they were allowed, that the Supreme Court found that, hey, you said instrument unknown. Mm-hmm. That was after the DA's office re-indicted the case, because originally in Wyatt, they said it was some type of hard object. They re-indicted the case to remove that, to make it less clear. And again, the Supreme Court said that that is absolutely fine. In that case, alleging that the object which caused her fatal injuries is unknown is more accurate and provides better notice of how the state plans to prove the aggravated assault at trial. That is the reason why I've attached so much importance to Wyatt is, again, it is the closest that I can find to the facts of this case. In Wyatt, the defendant had custody and control of that child, and ultimately that child was beaten to death, and the defendant was charged with malice murder, both for aggravated assault and I believe for aggravated battery, despite the fact that the DA's office, the state, was unable to prove exactly what he did. And the Supreme Court held that that is, given the facts of that case, it's not a general rule that we don't ever have to allege that. But in the facts of that case where we did not know, that was okay and did in fact put the defendant on notice. Judge, if we knew more, our lives would be easier if we could allege that, because that means we would have an easier time likely proving this. I don't believe that the state of Georgia is in any better spot for not knowing exactly whether Miss Motes beat this child with her fist, with her feet. At one point, law enforcement thought, well, maybe this girl has been run over. We don't know. Our medical examiner, judge, can't tell us. I believe that we have put all of the elements, all of the evidence, all of the allegations that we believe we can prove in this case, that it otherwise tracks the language of the statutes, and I believe would be likewise acceptable. Now, as to whether or not we need to put on, bring in our medical examiner, whether or not we need to, what type of evidence we would need to put up in a hearing like that. We'll actually talk about that in Wyatt as well. The defense counsel said, well, you know, this is analogous to demur based on the dates, okay? You had to put up evidence saying that you can no longer narrow the date range. You can't narrow it down beyond that. The Supreme Court held that the Supreme Court, in determining it is not like a date range, said the only way the state, and this is going to be on page 508 to 509, the only way the state to truly prove that it cannot specify the weapon or object the defendant used, which is the same situation we have here, would be to present all of the evidence the state has in order to show that the evidence does not allow identification of the weapon or object. That is, to make a full presentation of the state's evidence before actually trying the case. And that's why the Supreme Court held no, this is not an evidentiary issue. The court is to accept that the evidence, that the allegations in the indictment are true, to determine whether or not the defendant has been sufficiently put on notice. In that case, Judge, I believe that based on this, as unusual as this, and Your Honor, I don't know if we're going to see a fact pattern like this that we're going to see at trial many more times in our careers. This is, I believe, is going to be a factually unique and unusual case. But I believe that we have laid out all of the elements. As Your Honor is correct, although we did not use the term unlawfully, the indictment is very clear that this was done in violation specifically of OCGA 1651A. I don't know that she can claim, how do we not have to prove that it's unlawful, when in fact we say specifically she's violated the law, that we are alleging that. Further, I have not been able to find a specific case. The snow court passed on that. I haven't been able to find one saying otherwise. You need to have it in there, or it would be fatal. Now, I would, as to her exposure to the drugs, defense is correct about most of this, okay? There are a million ways for a child to be exposed to drugs, just like there are a million ways for a child to be a victim of blunt force trauma, okay? Again, if we knew more, if we knew that it was an injection, that the child was forced to take pills, that the child had been injured so badly she wanted to shut the child up and gave her a mouthful of something. If we knew that, we would allege that. If we thought that we were going to be able to put up evidence to show that, we would allege that. If when the time comes for trial, and we put up an eyewitness who says, oh, I was there and she injected this poor child with some kind of drug, then again, the state's not in, at that point, the state is in fact cooked. Your Honor is going to say, if you knew that, you had to allege it, you haven't done it, the probata and the allegata do not match, and as such, I'm not going to let you convict this woman. I'm not going to let you convict her when you are keeping all this information, that allegation to yourself to gain some type of advantage. However, it's very clear, okay, the state is not alleging this happened on accident. The state is not alleging that this child accidentally touched these drugs or that somebody around her blew smoke in her face on accident. We have affirmatively alleged this is an intentional malicious act. So, although there are any number of ways for somebody to do an intentional and malicious act to expose a child to drugs, we simply don't know which act it is. And again, this is not a unique situation in Georgia law. It's simply what it is. The indictment that we've drawn is based on the evidence that we believe is going to be presented at trial. I believe that if we present the evidence as we have laid out in this indictment, I believe that that conviction will be not overturned. I get how this looks. I understand. I've done enough murder trials and I've drawn enough murder indictments. I know how this one looks compared to the other. I told defense counsel, this isn't something we're doing specifically to her, that because this is a murder trial, we're going to go ahead and make the indictment extra squishy so we can get an advantage. Again, the state of Georgia is constrained by this absolutely just as much as the defense is. If going forward, we were to gain between now and whenever this case goes to trial, we were to get more information where we would say, oh, okay, perhaps this was the child hit with a hard object, or the child was run over, or the child was injected. If we were to find any of that. It would be our duty to go ahead and re-indict to allege that. I'm mindful of the case we had. We had a murder case a couple years ago. The old gentleman got hit by what I think was probably a weight, but that we were never able to figure out. We re-indicted that to say, at one point we thought it was a lamp. We re-indicted it to take that out there because we don't know what it is. It's not that we're trying to gain an advantage. We're trying to be forthright with the defendant. This is our evidence. If Your Honor strikes this indictment and sends us back to the grand jury, I simply don't know how we could change it. I don't know what allegation we could include, what act that she did of punching, kicking, throwing, running over. None of those, Judge, are what we anticipate we're going to be able to prove beyond a reasonable doubt. But, as in Wyatt, the defendant can look at this indictment and know what he is charged with. So I am going to ask Your Honor to deny the demurrer.
Thank you. And your response?
Just a few things, Your Honor. I would just like to mention, I don't think that the state necessarily mentioned count 5, but in count 5, at least they could have told us how that happened. And I think that certainly in no argument to the court, said that they could not do that. I'd also want to mention in Wyatt, like Your Honor pointed out earlier, it talks about the causal effect. And in all of those cases that I think you researched, which was probably what I looked at too, probably what the state has looked at, there is a causal effect. Blunt force trauma causing so-and-so, or exposure causing so-and-so, Did perhaps the exposure, was it I'm not certain exactly how to phrase it, for example, this is not a drug example, but, if somebody left a child out in the cold, exposed her to the cold and told her heart, stop beating because she went to a state of hypothermia, that would be an exposure example. And I do think Wyatt, one of the things about that, even though it might have been indicted twice, and I understand what the court has said earlier about the object, not being so concerned about the object, but it does say that object that was likely to result in serious bodily injury when used offensively to fatally injure her by causing damage to her brain. There is a causal connection within that. In this case, there is no causal connection whatsoever. And I have somewhat of a concern and it's been a good while since I've looked at some fatal variance cases, so I'm not prepared to argue cases on fatal variance. But, no doubt, the state is in a better spot. When the more general an indictment is, the better off the state is. I think there's no doubt with that. The state states that, well, if they get up there and says, oh, okay, I saw her do something, or, perhaps she confessed to me she did something or whatever, then that becomes fatal variance.
I don't necessarily agree with that.
That's where my argument was going. I did not see a court sustaining a fatal variance argument on that, whatsoever. So again, the state's in a better position with that. And I do want to point out, I think the court can take judicial notice of this. If the state thinks the word unlawfully is not important in a murder indictment, malice murder indictment, then why have they ever used it in a murder indictment in Hall County? I would point out that here's one, 2025 CR 000516 JGB, and within that malice count, it's on the 8th day of March 2025, did unlawfully and with malice of forethought. And that would be the state of Georgia versus Suzanne Renee Miracle, MERICLE. There's another case, it's 2026, CRO 398 JJD. That's the state of Georgia versus Christopher Daniel authors. Done unlawfully with malice or forethought. And there's these are just some examples. 2025 CR 0237 JJD, State of Georgia versus Demetrius Staley Few. And that spelling is D-E-M-E-T, D-E-M-E-T-R-I-U-S-S-T-A-N-L-E-W, why not W, why, and then F-E-W. And that count with malice murder was done unlawfully with malice or forethought. So the state knows it's important to put unlawfully. Why do they choose in this indictment to leave it out? Who knows? But, it is something that they could have easily corrected. They could go, that is easily corrected by going back and re-indicting. Now, and then the argument is, well, we just don't know. So let's do kind of whatever. We'll put something in there. We're just going to throw it up in the air. And what sticks, sticks, and what doesn't, doesn't. Maybe something will stick, and we'll get our guilty verdict, and then we'll ask this jury to kill this person. And, in this case, it's so much as Your Honor knows with, I think, your prior experience as a prosecutor, your experience as a judge, your experience as a juvenile court judge, that murder is so different. Death is different. And the death of a child is it shocks the conscience of a normal juror. They will look for a reason to kill someone that is charged with killing of a child. And to let the state get away with this type of an indictment, it's just not right. Now, so they say, well, later on, when we're indicted, we find anything differently. Don't they have a duty to investigate that now? Perhaps their medical examiner, perhaps they need to look at another medical examiner to see, would that person have a different opinion that, yes, I can tell you that these tissues over here were damaged, these organs were damaged. Or I can tell you, it's a lethal amount of drugs and that it was, whatever the lethal amount of the drugs would be. In order to at least put the defendant on some type of notice of what to defend against. And so, and now would be the time to correct. It's the easiest way to do it. Correct now. It's the safest way to do it, and it's the fairest way to do it. And that would be for all parties. Now, of course, I'm concerned with what's the best with the defendant. But I think in an indictment is with that cornerstone of the prosecution in the state of Georgia. A lot of states, I think west of the Mississippi, don't even have indictments. A lot of places have information and all. An indictment is that magical thing that gets you into court on certain charges, murder certainly being one of those charges. That those things need to be as perfect and as specific as they can possibly be. And, and one of the things with the grand jury, I kind of winced a little bit at the argument, where the grand jury didn't know. Well, the grand jury only knows as much as the state or as the state's witness tells that grand jury. Unless, of course, you got a grand jury that, that asks questions, and, of course, the defense is not privy to what that might be. But, Your Honor, we would ask the court to, as stated in our motion briefs, to dismiss this indictment on all counts.
I'm going to take the matter under advisement and review, again, several cases that were cited by the defense. Clearly, I've looked at the Wyatt case already, and several cases that were mentioned by defense, but I want to review one or two other cases that were mentioned, and I'll issue a ruling. In regards to the Motes case, we have motions set in November, the non-evidentiary motions, and then likely it'll be early 2027 for the evidentiary motions to be presented. I don't think that the deadline is even hit for the defense to file all of their motions, and so we'll just react once all of those motions are filed. The court is likely going to issue an order requiring the state to respond in writing to all motions so that I can prepare and understand the arguments from both sides in anticipation of those hearing dates.
Yes, Judge.
All right, Ms. Motes, have you had good contact? Yes, ma'am.
I'm sorry, Your
That's
Honor, for
fine.
interrupting. I think currently there is a challenge to the grand jury that is scheduled for September the 4th.
Yes.
I've not spoken with our expert lately. I do know he has received some information from the Council of Superior Court Clerks. I don't know if he has everything from the local clerk's office here. I will reach out to him and to see if we still on that September 4th date, or if he's needing any further time, or
Please
needs
let me
further
know as
information
soon
that
as
we need.
possible. I'm looking at my calendar for the fall, and it's packed.
Yes, ma'am.
So if I need to schedule another day for that motion, I'd like to know as soon as possible, so I could, one, use the 4th and perhaps swap some things around. When I issued the protective order that you presented to me, I made sure that our clerk was aware of it and had a copy of it. So I think he knew that the request for information was certainly coming.
And I know that that the clerk's council received it immediately too, or within a day. It was a very, very short period of time.
Excellent.
But I will let the court and the state know early next week.
Thank you. I
As
really
of that
appreciate that.
status.
All right. Ms. Motes, any issues that you want to address with the court? You've had good communication with your attorneys, and you're satisfied with with the work that they're doing for you. All right, and there's nothing else that you want to address with the court? All right, then we'll stand in recess with the Motes case, unless I issue an order moving the 4th. I'll see everybody back on September 4th for that challenge.
Thank you,
All right,
Judge.
we'll stand in recess.
Can I talk to her briefly?